Hello, it's Philip Taylor from Richmond Green Chambers speaking, and I'm looking this morning at a book from Jordan's. It's Disciplinary and Regulatory Proceedings in the 6th edition, and it's written by Brian Harris, OBE Queen's Counsel, and Andrew Carnes. We've given it a title, The Leading Work on Disciplinary and Regulatory Tribunals, now in a 6th edition. This is the book, green cover. It's quite heavy, it's about 550 pages long. I like the coloured area, this sort of black area there, which is quite useful because that actually covers the part 1, which is the actual regulatory proceedings themselves. You can probably just see the note there. And that's the bulk of the book. It's got the standard referencing at the side and detailed footnotes. There are a lot of cases referred to. There's a nice detailed index, chapter heading at the front. As I say, the cases are there, and then at the back you've got a reasonably detailed index. And you've got also an extract from the 1st edition which sets out why this book is actually published the way that it is today and where we are. So let me just tell you a bit about the book. We've given it this title, as I say, as the leading work, and we say this: we live in an age of increasing regulation, and therefore its enforcement by ever more numerous and diverse regulatory and disciplinary tribunals is becoming more apparent, and those are the comments really by the two authors, Harris and Carnes. If you practice therefore professionally in any aspect of tribunals involving disciplinary charges, specifically in healthcare, financial services or legal services, take note then that this is the leading work in this important area. The emphasis covers two things, the first being the prosecution and defence of disciplinary proceedings against firms and individuals, either with respect to professional conduct or the regulatory environment. Notice the words prosecution and defence. It immediately connotes criminal, and it's effectively extra criminal when it comes to the concept of what they do. It's not a Crown Court matter, it's not direct criminal law, but it's basically looking at it now from that point of view. The other area it covers is the authorization of a firm or individual to participate in an activity regulated under public or private law. Quite rightly, of course, the authors warn against over-reliance on regulation as a panacea for all life's ills, complacency amongst regulators or poorly focused over-regulation being one of the things they have highlighted. They cite the increasing scepticism on regulation amongst the public that can result, especially in the wake of the catastrophic failure of regulation to foresee or prevent the current banking crisis, as pointers in the current direction. So few would argue with the authors when they say that regulators across all disciplines have a collective responsibility to deliver efficient, effective, proportionate and fair processes in which the public can have confidence. Well, that's interesting because there are some areas that are covered. I mean, teaching is another area that's developing at the moment, and yet the press and banking seem to be excluded. So there may well in this century be some changes as we look again at this area, which is a subdivide really, if you look at it now, of criminal law. The book therefore examines the general principles applicable to all regulatory and disciplinary tribunals. The basis of the tribunal's authority is analysed, together with the extent of the jurisdiction, natural justice, human rights and so forth. All the usual suspects are there, if you like, in terms of what is being looked at. And it also covers hearings, evidence, appeals and enforcement. The new edition casts an erudite eye at the new regulatory proposals for financial services, which are going to be very controversial, of course, as well as developments in healthcare and the regulation of legal services brought about by the Legal Services Act 2007. Obviously there are recent developments in disciplinary procedures and important case law which I've indicated. It's an eminently readable book, and it's both thorough and analytical in the way that it approaches the subject. It certainly looks at special interest areas which of course may well be directly relevant to whether you're advising a specific client who comes to see you or you have a more general interest in the subject. I think it's particularly relevant for practitioners at the coalface when you look at part 2 of the volume, which looks at disciplinary and regulatory arrangements in practice. That's the small bit towards the end, not the large main bit on the proceedings themselves. There's a useful practical advice section for lawyers and lay members of disciplinary tribunals as well, and particularly the comments on courtesy and consideration, and an item recalling Kipling's "don't look too good nor talk too wise" admonition, which could be good advice. So let me conclude by saying, as you would expect in a reference work of this stature, there are extensive cases and the various statutory instruments and so forth. It's a how to use this book section, I think, of the work, which is very helpful, and it's something you should look at, because in addition to it you've now got an author's website which enables readers to conduct further research. Now, I can't put the actual website details on the reviews because that's normally not allowed on the websites, but certainly you can find the information very easily by Googling. So thank you very much to Harris & Carnes for an excellent new edition. Bye bye.